Hey y'all, thank you so much for joining me this afternoon. So I know it's probably lunch break, so I'm gonna try and keep this pretty brief. My name is Trish Butcher. I am the attorney with Arch Legacy Firm, and thank y'all so much for joining me. And let's go ahead and jump right in. I know your time is very valuable, but if you hang around to the end of this, I promise it will be worth it. There's a bonus at the end, so hang with me. And just let me know in the chat if you ever have any questions, and I will try and answer them at the end. So you are in the right place if you have someone or something you care about and want to protect. You don't know who to name for guardians or other fiduciary roles. You are nervous about meeting with an attorney. There are a lot of attorneys I personally would not want to meet with, or you just don't know where to start. Estate planning is not something we usually typically sit around the dinner table talking about. So a lot of people don't know where to start, don't know what to do, don't know what documents they need, and that is totally fine. I don't ever expect any of my clients to know that information up front, but if you hang with me through this webinar, you will learn a little bit today. So the reality is that estate planning is not really about us. It's not really about me or you. It's really about the people you love the most, the ones who are going to know whether you took care of it. And I tell people all the time that with estate planning, we do a little bit more work up front to make it as easy as possible for our family on the back end, because when losing someone that you love is never easy, but going through probate, going through these confusing processes, not knowing what assets there are, it just makes it so much harder. So a lot of my clients, what we end up doing is we do a little bit more work on the front side to make it as easy as possible on the back side, and it definitely gives us the ultimate peace of mind. So a little bit about me before we get started. I am Athens born and raised. I went all the way through Clark County schools, graduated from Clark Central, went to UGA. I am married and I have one son who's three, almost 3.5. And he is really the reason that I wanted to start my firm. And I have two furries, a cat and a dog, Whiskey and Woodford. And I'm lucky, I'm very fortunate. Most of my family still lives in Athens. I have one brother who lives in Denver, but most of my family is all really close. So like I mentioned, I went to UGA before going to Emory Law School. I worked in Atlanta for the Medical Association of Georgia for many years before becoming a mom in 2019 and then opening my firm in the beginning of 2020. So I own this firm. I work here with my sister, which is a lot of fun. And we have we are client services director, Sarah, and we are all moms. And our goal is to work with other moms and families and protect their kids, just like we've protected our own. So my why for my law firm is absolutely my son, Max. I definitely wanted to make sure that he was protected no matter what, way above and beyond what most estate planning attorneys offer. So we do something called a kids protection plan. And this was created solely based out of my need to do something that really comprehensively protected him in case something was to happen. My grandmother's estate utterly failed miserably, and my dad was in probate for 4 years. So I want to make sure that other families don't experience this. In reality, this is huge for me. I so want to make sure that my clients' families don't ever experience anything like this. It was very stressful and very, very, very expensive for my dad to have to go through 4 years of probate, primarily because the estate planning attorneys that my grandmother used just failed. They failed at their job, and it was almost like they committed malpractice, but good luck suing attorneys for that. So also my dad's will, he went to a very well-known attorney here in Athens, and he was single at the time, a smoker, and the attorney drew him up a will leaving his assets 3 ways to his 3 children, and that's it. No incapacity documents, no medical power of attorney, nothing. So basically they charged my dad for the law, because by law his estate would have been left 3 ways amongst his children. So my dad paid for nothing, and you best believe my dad has a new estate plan now that is much more robust than that. So do you have people that you love and want to protect from court and conflict? And that does actually include yourself, because estate planning does include incapacity documents. So it's loved ones, family, brothers, siblings, spouses, kids. Who do you love that you want to protect from court and conflict? Because in reality, that is what estate planning is about. So what we are going to learn today is how estate planning can protect your family. We're going to look at some scenarios of just the generic Smith family. And unfortunately, trigger warning, they're going to have some bad days ahead. This is estate planning. It's a little bit morbid. My joke is that I prepare people for death, but what I really do is I give the ultimate peace of mind for my clients, and we plan for the worst, but we absolutely hope for the best, which is that you live many, 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 many more years. And I see y'all many more times to update your plans and continue as your life marches on. So let's meet the Smith family. So you have the dad, John, the mom, Samantha, the son, John Jr., and then the little daughter, Allison. And they're just your average American family who is about to go through some really tough times. So dad is flying out of the country for work. Mom has some work meetings. So they call their longtime babysitter over, and the kids love the babysitter, very excited about getting to spend the day with her. But of course, because this is estate planning, obviously this is where things start to go bad. So Samantha is on the way to the work meeting when she gets an email saying, hey, meeting's been postponed. So she decides to hit the gym. So she goes to the gym, she locks her purse into the locker, gets on the treadmill, and bam, has an aneurysm and unfortunately passes away. Meanwhile, the babysitter's calling and calling, not getting through to her because her phone was locked up in the locker room with her purse, doesn't know what to do. So what do you think a babysitter would do in that circumstance? The dad's out of the country, babysitter can't get a hold of mom, doesn't know what to do. Well, most likely, the babysitter is probably going to call the police. And if the police come, unfortunately, the babysitter cannot keep the kids because she is not allowed to. So the police will have to take the children into protective custody with strangers while the dad is frantically trying to get back to the country. So, and in reality, I know a lot of people don't think about this, but this is a real possibility that if you have a babysitter over who is not related to you and has no legal authority to keep your children, and something happens, your babysitter will most likely eventually call the police, and the police will take your kids into protective custody. It is actually the law. Police are required to do this. And sometimes they do it even if your kids are related to their babysitter. I have gotten a lot of misinformation, a lot of no's, yeses, a lot of conflicting information on that when I've talked to police officers. So you just don't really know what's going to happen. So that was with no estate plan whatsoever. Let's look at what happens if they have a simple estate plan. They've done a will, they named guardians. What happens in that scenario? Well, unfortunately, the scenario is going to play out pretty much the same. Babysitter is going to call police. Police take children into protective custody. Dad is frantically trying to get home. Kids are extremely traumatized and do not know what is going on. So simple estate planning does not help protect against this circumstance. So emergency guardians, these are, people that we don't really think about a lot, and a lot of attorneys don't name emergency guardians for their clients, but I think it is very, very important. So emergency guardians are friends or family who live nearby who can step in and keep your kids legally in the event of emergency. So if this family had worked with my firm, the babysitter would have actually had laminated instructions that had the list of emergency guardians. So when she went to call, she would have called them first instead of the police, because guardianship is equally about what happens in an emergency as it is about who raises your children if you cannot. So while permanent guardians are absolutely so crucial, emergency guardians are crucial as well. So what if they did have an advanced estate plan? Babysitter would have called one of the emergency guardians. He would have come prepared with legal authorization to keep the children. The kids know him, the kids trust him. They get to continue having a little bit more normalcy while the dad rushes home to get to them. And then no trauma, no strangers staying with. So this is something that our kids protection plan does, is it makes sure that these kids stay as safe as possible in the event of any unforeseen circumstances. So because this is estate planning, unfortunately, it's just going to get worse. John now realizes the importance of an estate plan, so he gets life insurance, does an estate plan, and then boom, dies in a car accident. So naming guardians, hopefully in his estate plan, he did name permanent guardians. So when we're naming guardians, it's really important to think about a lot of different things. It's not necessarily just who's the most closely related to you. There are a lot of reasons why you might want to consider really good friends, other people who might share similar values, similar spiritual beliefs. Maybe they have similar financial approaches. Maybe they live in the same town so that your kid can keep going to the same school, similar child rearing ideologies, and very importantly, access to loved ones. So there are a lot of things that go into picking out guardians, and it doesn't necessarily have to just be someone you're related to. It can absolutely be a close friend or a cousin or something like that. Now, remember that naming godparents is fantastic. And if you want to raise your child in the church, or that's something that your family holds dear, that is amazing. However, godparents, that gives them no legal authority to keep your kids. So naming someone as godparents does not give them legal authority. The judge can name anybody they want to name as guardians if you don't. So, do you know who you would name as legal guardians for your kids? So at this point, I am going to share a little poll real quick. I'd love to get your answers for this. Do you know who you would name as guardians if you have minor kids? If you don't have minor kids, don't worry about it. I know not everybody does, but do you know who you would name as guardians? So I got Jesus take the wheel. I got yes. Got no, Jesus take the wheel. Gotcha. Okay. So got a lot of different mixed results there. Thank you for sharing. It's very common. I think one of the main reasons when people tell me they haven't named guardians yet is because they don't know who. And all I can say is that you are more qualified to make that decision than a judge is. So it's very important that even if it's really hard to figure that out, that you do figure that out. But if you work with a qualified estate planning attorney, they can help you make that decision as well. They can help you kind of brainstorm through and think of the different alternatives. And I almost always ask my clients to do a successive list. So first choice, second choice, third choice, and I walk them through that as well. So sometimes that can also, if there's any disagreement amongst the spouses, it can also stave off that as well. So back to the presentation. So the children move in with the guardians and they start to heal. But what happens to their inheritance, the life insurance money, any retirement accounts, everything like that? So let's find out. Result, kids inherit immediately. So a lot of people don't realize that if they name their children as contingent beneficiaries on any life insurance and retirement accounts, their kids cannot inherit this money because minors cannot inherit. So what happens is that all this money flows into the probate process and the judge appoints a financial conservator. And then when the children turn 18, they automatically get whatever is left in that fund as a lump sum check. And as you can imagine, I don't know what I would have done with a lot of money when I was 18, but I would have probably had a better time at UGA than I did. So, and I had a lot of fun at UGA. But so it's very, very, very important to know that minors cannot inherit funds. And if you leave any assets to your kids, or you don't name beneficiaries, and something happens to both you and your spouse, or you if you're a single parent, all this money is going to flow right into probate, and they will get a lump sum check when they turn 18. So what is probate? Probate is the court supervised process. Sorry, typo, I need to fix that. Court supervised process for distributing assets after a person passes away. So after a person passes away, all of their assets will flow into the court process called probate. Their family will most likely have to hire a probate attorney. The judge will oversee it. There will be a wait period before they can get in front of the judge, most likely, depending on where they live. In Clark County, it's about 6 to 12 months for an uncontested probate. For surrounding smaller counties, it's 3 to 6 months. It totally depends on, where you live and how backed up the courts are. So a will. So a lot of people think that having a last will and testament will prevent their family from having to go through probate, and this is actually false. So a will just simply tells the judge how to distribute your assets. It is a legal directive for the probate process. So it will name who you want as your executor, who you want to get your assets, and who you want your permanent guardians to be. So wills are very, very important documents, but they are not the end all. They do not control any type of assets that are beneficiary designated, and they do not protect your kids if they are minors from that probate process as well. So having a will equals probate. Your private matters become public information during probate. Wills are very easy to contest. Courts involved in every step of the process. No distribution until the judge orders it. That means that while your assets are tied up in probate, they are completely tied up in probate. And your family cannot access them, including to sell the house. If they need to sell a house, your house will sit there and they will have to continue to pay for it until the judge signs off on it. There are multiple probates if you own assets in more than one state, and the process takes typically over 6 months to complete. In Atlanta, that's looking more like a year to 2 years, by the way. Atlanta is the worst. In Georgia and other states, it totally depends on the state. California is one of the worst. I think up to 4 years for a non-contested probate. If probate is contested, it can go on indefinitely. So how do kids inherit with a will? So minor children cannot inherit money. All assets, including retirement and life insurance, are thrown into probate, and the judge appoints a financial conservator, as I mentioned. And who will the judge choose as the children's financial conservator? Will it be their guardians? Will it be close relatives? Will it be a professional fiduciary? We don't know. Every judge gets to decide what they believe is best for every circumstance. So it's very important to remember that if you don't make decisions, the judge makes them for you. When will the children receive their inheritance outright with no protection or guidance? At 18. So again, your kids would get a lump sum check for whatever is left over at the age of 18, and they can go spend it exactly how they want to spend it. And yeah, a lot of kids, that would probably not be the best case scenario. So let's do something better. Let's look at a better option with estate planning. Result 2, kids receive inheritance in a trust. So instead of them ever receiving the money outright, the dad created a trust, whether it be a living trust or a lifetime asset protection trust, and all of the money flows into that trust for their benefit, for them to be raised. And then when they reach certain ages, or if it stays in trust, it's protected, and they can withdraw that money as necessary, but it stays protected and it stays under guidance of the trustee until they reach at least a certain age. So it's very, very a much better option for a lot of families, and it protects all that money from your kids inheriting at 18. It also protects that money from going into probate. So trust can be extremely beneficial. Now, what is a living trust? So a living trust is a revocable living trust, and it is will substitute, although you would still have a will. So I like to consider it as a will add-on. It goes above and beyond a will. And the most important thing to know about a living trust is it helps your family avoid probate. If you have a living trust and it is properly funded, which just means that you have moved your assets into it, then your living trust will make it so that your family does not have to go through probate at all. A living trust is not asset protection. It is purely a probate avoidance tool. And what it means is that your share of jointly owned assets go directly into your trust. Beneficiary designations are updated to go to your trust as well, and all trust assets are immediately available for your loved ones, no court required. So with a will, you have an executor. With a trust, you have a successor trustee, and that successor trustee can immediately step in and immediately access all of your assets, gather them, do whatever they need to do to make sure that the guardians have what's necessary for the kids. Or if it's a spouse, that your spouse has what's necessary. Because if you don't jointly own everything, including your house with rights of survivorship, even a house, even a spouse might have to go through probate if their spouse passes away. So other considerations with estate planning, we are incapacity documents. So power of attorney, who do you want to manage your finances if you are incapacitated but still alive? If you're in the hospital and you are in a coma, who do you want to access your bank accounts to pay your taxes, your utility bills, your mortgage, things like that? Healthcare power of attorney. Who do you want making healthcare decisions if you're not able to? Advanced healthcare directive. What do you want to happen at the end of your life? This is a very limited document, but it does apply in two circumstances towards very end of life. If y'all have heard of the Terry Schiavo case, this is what she desperately needed, was an advanced healthcare directive to keep her family out of conflict. So lesson one, our children are our most important assets and they need to be protected no matter what. So guardianship is not only about naming permanent guardians, it's also about naming emergency guardians. And we offer something called a kids protection plan. So we also do minor medical power of attorneys so that these people are also able to get your children medical care if needed. And that's so important. As well as there's babysitter instructions and little cards for your wallet that say, hey, if you're looking through my wallet trying to figure out who I am, please contact one of these people. Lesson number two, wills do not avoid probate, and probate can be a very long, public, and costly process, but they do name permanent guardians, which is very important. So wills are very important documents. They're just not the end all be all. Lesson number three, and this is honestly kind of a new lesson, but it's important to point out, is that a review of all of your assets must be a part of your estate planning conversation. A document alone is not enough to protect you. There's over $1 billion in the Georgia Unclaimed Properties Department. This is from people who have passed away and their families didn't know that their assets existed or how to get access to them. And you definitely, all these assets that you've worked booty off for, you definitely want to go to your family. So it's very important that you have a wealth inventory so that your executor or your successor trustee knows how to get access to those assets. So Arch Legacy Firm, the firm that I started in 2020 because I wanted to create a better solution for families. How are we different? So traditional lawyers typically charge hourly fees. So surprise fees a lot of the times. They do knee-jerk response to problems instead of planning ahead. They are transactional, so they do a lot of one-size-fits-all documents, fill in the blank wills. They meet with their clients, they give them their documents, sign and witness notarize, and that's it. That's the last time they talk to their clients. So what do I do differently as a personal family lawyer? So let's get rid of all of those. And I charge flat fees with very transparent pricing. I want my clients to know exactly what they're going to pay me if they decide to move forward with me. We plan ahead, so we plan for all different types of circumstances. My documents are a good bit longer than I'd say 90% of attorneys' documents, but there's a reason for that. It's because they are much more inclusive, and there are things that are in there that if you need them, they're very, very important to be in there. Plans are created specifically for you. So there's no fill in the blank documents. These are all personalized, comprehensive documents that are created specifically for your goals and your family situation. And then finally, we're a trusted advisor who will be there for your family. So we do 3-year reviews for all of our clients complimentary, make sure that no amendments need to be done, make sure that everything stays up to date. And then you know that if anything was ever to happen to you, I will be there for your family. And that is so important that they have someone to turn to ask questions for. Now, my promise to all of my clients is that their estate plan leaves no stone unturned and will give them the ultimate peace of mind knowing that the loved ones and assets are kept out of court and conflict. Y'all, like I said, my dad went through 4 years of probate. So it is truly my goal to create plans that will actually work and protect them and their families in the event of them passing away. And it's very important to me. I'm very passionate about it. I also want to make sure that their kids are protected no matter what. So, like I said, I'm overly transparent about my pricing. So I want to share what my prices are. The family plan is the will-based plan. So for families that don't have minor children or maybe don't have a whole lot of assets, and you just want to do a very comprehensive plan that includes the wills instead of the living trust, we do offer these. They are $1,500 per individual, $2,000 per couple. With my pricing, I charge half up front and half after signing meetings, so about a month apart. And I do invoice, so my clients are able to pay however they need to pay. If they need to pay via credit card, that is fine. I do not charge an upcharge for that because I understand it is a lot of money. Also, if you own a business, please, please, please write this off with your business. It is legal consulting. Write it off. Talk to your CPA about it first, but I highly recommend you write this off with your business. And if you do own a business, the family plan is probably not for you because we do want to make sure your business is protected as well. But the family plan is fantastic for some clients, and for some clients, this is all they need. And I will never tell my clients they need to upgrade if they do not. So this includes wills for each of you, healthcare directives, healthcare power of attorneys, financial power of attorneys, and that kids protection plan. Again, this is a will-based plan, so their family would have to go through probate for any assets that are probate assets, but you do know that everything is legally solidified so that your family, there should hopefully be minimal conflict. Now, trust-based plan, this is everything the will-based plan was, but it does include that revocable living trust, and it includes us transferring your primary residence to that trust for you automatically so that your house will not go through probate if anything was to happen to you. So the price for this is, for the whole package, not additional on top of the will, this is the whole package price, is $3,000 for an individual and $4,000 per couple. And again, it's going to include 2 wills, healthcare directives, healthcare power of attorneys, financial power of attorneys, kids protection plan, that joint revocable living trust, and deed to transfer your property into the trust. So for people who want to do a little bit more work up front, pay a little bit more up front to make it as easy as possible for your family on the back end, make sure that we're avoiding all chances of conflict and your kids inheriting as minors, this is probably the best plan for you. For families that really want to name guardians for their kids, but don't really have any assets yet, I have some great news, and that is that you can actually name legal guardians for free at archlegacyfirm.kidsprotectionplan.com. Again, this is free. It is just to name permanent guardians. It doesn't have anything to do with a will or anything like that. But if you follow all the instructions on this website, you can name guardians completely for free if you're not really worried about asset protections right now. So my process, it takes about 8 weeks from start to finish, but about 4 weeks before everything is actually effective. So the first meeting is called an initial planning session. That's where we meet. I get to learn a little bit more about your family, your goals. And then from there, we schedule a short design meeting if you choose to work with me. The initial planning session is really just an educational session. The whole goal is so that you can make an informed decision about what makes the most sense for your family. So during the design meeting, it's usually about a 20 to 30-minute meeting. It's where we just solidify who you want to name for all these important roles. I give you a cheat sheet ahead of time so that you can start thinking about these things. If you drink, maybe with a glass of beer after your kids go to sleep. After the design meeting, we schedule a signing meeting for about a month out. The signing meeting is where we go through all the documents. I answer all questions. I walk you through them, and then we witness, sign, and notarize. And at that point, the documents are 100% effective. From there, we do a final binder delivery meeting. At the binder delivery meeting, I give you all your documents, as well as the original and USB copy of your electronic copies. And we also offer something called a life and legacy interview. Now, this is not everybody's cup of tea, so this is not required, I promise, but it is very, very special. And if you choose to, it is included. And it's where I interview you and ask you questions about your childhood, favorite memories, family, how you met if you're married. And really, it's just a video that if anything happens to you, your family does have this video to remember you by after you're gone. And I have had a lot of clients who said they would give anything to have a video like this of loved ones that they've lost. So again, not everybody's cup of tea, but it is very important if you want to. So thank you for hanging in there with me. I know that this has been a lot of information to process, and it's the middle of the day, so I very, very much appreciate y'all hanging with me. As a gift, if you decide to book an initial planning session with me, I will give you a $250 discount on your personalized estate plan. So either deduct that $250 from the $2,000 or the $4,000 package. And then also, I would love to give you a 60-minute massage, not me personally. You don't want a massage from me, that would suck. But I will give you a gift card to a local Athens studio who I love, and you can protect your family and then also relax at the same time. So if you book an initial planning session with me within the next 7 days, you'll get a $250 discount and a 60-minute massage. You just have to book within the next 7 days. You do not need to schedule an appointment within the next 7 days, if that makes sense. So if you would like to schedule your initial planning session or your family wealth planning session, you can go to archlegacyfirm.com/FWP-schedule. You will be getting a follow-up email from me about this. It will have that link there as well. If you do have any questions, please do not hesitate to email me at trish@archlegacyfirm.com. Also, if you have any questions, please feel free to share it in the chat box right now. I'm happy to answer them. But again, if you do want to schedule that initial planning session with me and get that discount and that free massage, you can do so online at archlegacyfirm.com/FWP-schedule. And I only have a couple more spots open for August, so highly recommend jumping on that quickly. I'm almost full, and soon I'll be booking into September. So thank y'all again so much for joining me. Taking the time out of your busy day. And again, please feel free to email me if you have any questions, trish@archlegacyfirm.com. At this time, I don't see any questions in the chat, so I will let you get back to your busy day. But again, archlegacyfirm.com/FWP-schedule if you do want to schedule that initial planning session with me. I hope everybody has a wonderful day, and I hope to meet with y'all soon and help you protect your family. And again, please email me at trish@archlegacyfirm.com if you have any questions. Thanks, y'all.